CR1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in DAKOTA v. SEDONA Oak, 1 CA-CV17-0767. Out of respect for counsel in the court, please turn off your cell phones or at least set them to vibrate. Each side will be allocated 20 minutes for rebuttal. Appellant, you may reserve a portion of that time, but if you wish to do so, you will need to keep track of it yourself. Counsel, we have read the briefs. We conferenced this case this morning. We are familiar with the facts and your arguments, and we encourage you to keep that in mind as you present your arguments here today. These proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, counsel for appellant, you may proceed.
Thank you, Your Honors. May it please the Court. Brad Weech and Marshall Hunt for the plaintiff appellant, Dakota Territory Tours, and the principals of that company are here with us today. This appeal is a little bit different than judgment, as this is an interim item, and there have been things that have been going on which I would like to point the Court to update the Court. They are all matters of public record, and the Court can take judicial notice of them.
Part of our record on appeal?
Pardon?
Are they part of our record on appeal?
Yes and no. The index of record.
The yes.
The index of record. The reason it's yes is because the index of record has been transmitted to this Court, but we believe that it's not complete. It only goes. It's dated December 3rd, and there are.
I'm sure you're aware that we can't sort of try this case on a vowel. We have to rely on the appellate record.
I understand that, Your Honor, but I believe that you can take judicial notice of the fact, such things that the trial court has ruled on the motion for summary judgment that is referenced in the briefing, and that was left open as to the trial court having to have the opportunity to rule on that. And as to the merits and as to the harm components, the things that I intend to address and bring the Court up to speed on are as a matter of public record, and we would ask to supplement the record with those public documents.
As you correctly pointed out at the beginning of your presentation, this is a limited proceeding, and our jurisdiction is limited only to the order dissolving a preliminary injunction. The issues that may have given rise to the issuance of the injunction, or the manner or the reasons for its issuance, none of that is properly before us. The only question I think that we can properly answer, and if you disagree, please let me know, is whether the Court properly considered the condition placed upon the injunction and acted accordingly based on the information it had.
I would address the Court to the standard of review for this appeal, and that is that, and it's not accurately stated in the answering brief, it actually is two parts. Part of it is de novo as to the interpretation of statutes.
I'm not there yet. I'm at jurisdiction. What do we have jurisdiction to consider?
You have jurisdiction to consider the dissolution or the dissolving of the preliminary injunction.
Correct.
Yes.
Okay.
And I don't intend to go outside of that. But in doing so and doing your review of that, you have a two-part, part de novo and part abuse of discretion standard. As to the de novo, you are to look at things such as interpretation of statutes, interpretation of rules, and interpretation, in this case particularly, of contracts de novo. And as to the other factual issues, that is an abuse of discretion. And so I will just simply identify for the Court what it is that I intend to bring the Court up to speed on and leave it at that. But one is the motion for summary judgment that was pending when the briefing was done has been ruled upon, and the Court made further findings at that time that go to the merit and to the harm that's involved in this case. In addition, there is another case that was brought up in the answering brief, one by Guidance, the other proposer, and the argument was made by SOCA that they were now suffering damages. That case has actually been on hold for 5 months because a motion to dismiss was filed by SOCA after the briefing, and then an open extension was given to guidance and has been standing that way for 5 months. That goes to the harm arguments that were made in the answering brief. SOCA has also issued a new lease to guidance, and that lease is in existence, so guidance is still in its place, the other competitor. All things going to the harm issues and or to the merits. And so I think it's important for the court to know that. I do not want to go further if the... Why?
But in the context of this case, why does any of that matter?
Because, Your Honor,
there will be another appeal someday, I'm sure, of the proceedings that are ongoing. But we are here on this one tiny little piece. Why does any of that bear on the issues we have to consider?
As I said, your determination is not simply just one of abuse of discretion. You are entitled and responsible to rule on issues of law. And some of those issues of law have to do with the merits of the case, which I've just described to you, and an update on the arguments that were made to you about the harm. Not only the irreparable harm, which has not changed, but the balance of harms, and that was argued in the answering brief.
The only issue here really whether the Board of Supervisors was given an opportunity to evaluate responses to the RFP.
Oh, no, Your Honor. Oh, and let me explain.
I'm sure this is a much more colorful painting in the case proceeding in Superior Court, but I don't see any other issue properly before us at this time in this appeal.
Let's take that as an example. That was an issue of law, a contract interpretation issue, where the trial court determined what the RFP actually provided, interpreted that RFP. That's an issue of law. This court looks at that de novo.
Right, but it did that at the initial grant of the stay, correct? Which
It
you
did.
didn't appeal. And
Pardon?
then- which you did not appeal.
No, we won that.
Right. And then the court dissolved the stay based solely upon whether or not the condition of that initial stay had been fulfilled. And that's what you've appealed.
Your Honor, you can't separate the other arguments were made in order to obtain that preliminary injunction from...
We can. We have to. Our jurisdiction is limited to what has been appealed.
The fact that you have one very narrow statute that gives you one aspect of this case you can appeal is not an opportunity to bring the court up to speed on proceedings that aren't yet concluded and get advisory rulings on issues of law. We are really only entitled by law to consider this one very narrow question.
Let me explain it this way. The dissolution order was not just based on that one issue, because the trial court, in creating the preliminary injunction, ruled in other ways. Now, yes, the trial court did say, if you go out and just present this to the county, that's all you have to do. That did not take away from the other findings of the trial court that put the preliminary injunction in place. So if this court is willing to accept and should accept the other findings of the trial court in creating the preliminary injunction and is only going to look at the issue of whether the court rewrote the RFP and did so inconsistent with the language of the RFP, then I think you're looking at the broad spectrum anyway, because you're taking everything that was granted or everything that was a basis for the granting of the injunction as if it were so and if it is still true, and only going on the basis of deciding whether the court interpreted the RFP incorrectly, essentially rewrote it and said, no, you do not have to have the county participate. You just have to kind of send them a couple of the papers because not all of it was...
SOCA bound the county to participate.
SOCA wrote their RFP. We did not.
Well,
The answer to your question is I don't think they could. So they wrote an impossibility into their own RFP. They also wrote in the possibility that they could cancel it at any time and redo it and fix those things, and they still have not done that. Pardon me to say.
And you're still litigating those issues. I'm confused as to why you're in this court if the real issue is all these issues you're talking about. Those have not yet been concluded. If the real issue isn't Yavapai County participation, then what is the real issue?
Your Honors, I understand where you're coming from, and I respect that, and I do understand it. And we stand firm on that issue, that there is nowhere in the RFP that it says that you can just simply present it to a county attorney, not to the governing body.
So if SOCA had written an RFP that said, we want buy-in from the People's Republic of China, and the People's Republic decides that it doesn't care, where does that leave us?
It leaves us with the prospect that the trial court used only one factor in determining to undo a preliminary injunction, that it found clearly on the basis of irreparable harm that was catastrophic, that the balance of harm weighed heavily, if not completely, in the favor of SOCA, that there was no public policy issue, and that has since added to its determinations on the merit by denying motions to dismiss and then ruling as a matter of law that the issues in this case should go to a jury because there are issues of fact. And in that finding, in that minute entry of the 24th of December, just a month or so ago, made additional findings.
It sounds like you're asking us to supervise the trial court.
Your Honor, Court of Appeals always looks over what happens in the...
After it's done.
I'm not sure how that fit into the question.
Well, it sounds like you're asking us to supervise what the trial court is doing and give guidance for a proceeding that isn't yet concluded, and that's not what this court exists for.
Let me explain it this way, going back to your jurisdictional issue. The granting or the dissolution, the dissolving of a preliminary injunction is one of the very few statutorily mandated basis of jurisdiction for this court.
We acknowledge that.
And so in that vein, as to that issue, litigants are entitled to come to this court, especially in situations of catastrophic damage that is irreparable, that the court found to be catastrophic and irreparable.
Right, but the court then imposed a condition upon the granting of that.
You did.
You did not appeal that decision below. Then when the court found that that condition had been met, you appealed. So the only issue I see before us is whether that condition was satisfied or not. Now, I would say you need to spend some of the next 7.5 minutes trying to convince us of that issue.
I will take that instructions and follow it. I had the opportunity to clerk for this court many decades ago, and that is one of the things that I learned was if you ask a question, that's what they're focused on, address it. Your Honors, in our briefing, you've read the briefing, you've conferenced on this, I'm familiar with those processes. In the briefing, we pointed out that let me just hit it right on the head as far as the most dramatic thing, and that is that the court did order that it be presented to the county of Yavapai for them to approve it. Okay? The biggest point on that in our briefing is that the county cannot act except in an open meeting. And contrary to the answering brief, that doesn't mean that a county attorney can simply turn it away and say, we don't do that. The county attorney does not have that authority. A distinction is even made in the briefing, in the answering brief, about trying to make a distinction between inaction and inaction. And yet those are both decisions.
Did anybody go to the County Board of Supervisors and call to the public or ask that it be put on the agenda that the county board address the gross overstepping of authority by its attorney? Has any board member weighed in and said, my God, why aren't we being presented with this opportunity in an open meeting?
Nope, I don't think that has ever occurred.
If it's never put on the agenda, that it can never be considered in an open meeting.
That's correct.
And the county board is under no obligation to put anything on an agenda just because it's requested.
And so, my conclusion and our conclusion, that the county never was given the opportunity to do that. SOCA never went to the county and did anything but try to present part of the proposals to a county attorney. They never went to a meeting. They never stood up in those meetings at public comment. They never did anything except go to a county attorney, present part of it, and have the county attorney tell them that we don't do that.
Well, the RFP also required the FAA to weigh in. How come you're not arguing that there's a foul because the FAA declined?
We did argue that in the preliminary injunction.
Here we are, and I don't see that argument in your briefs.
No, it is. We addressed that in the brief.
Should we?
Absolutely, we addressed it. In fact,
so you think we should actually order now that the FAA participate as well?
Your Honor, I don't think that this court has jurisdiction to order that the FAA do anything, nor that the county do anything. But we did not write the RFP. They wrote the RFP, and Judge Napper specifically found that they had an obligation to comply with the terms of that RFP, especially under the circumstances that they could cancel it, fix it, and do it over. This argument about impossibility in the briefing just simply is absurd. It is just...
So your argument would be then that the remedy coming out of our court would be to say the trial court erred as a matter of law in finding that impossibility excused performance, because what they should have done then is canceled and reissued their RFP without that condition if it is impossible.
That is one option.
What are the other options?
The other options are that he misinterpreted the RFP. There is no provision in there that says that the county merely needs to be given an opportunity to review this. That's not what it says. And as to the FAA, it's in all caps and bolded that the FAA has to participate. They very well could have fixed these issues and then done a new RFP, and they can still do it. For whatever reason, they have refused to do so. I would like to reserve the last 3 minutes, but I will accede to whatever questions the court wants to ask.
No questions.
Thank you.
Thank you.
If it please the court, my name is, can you pick me up? Okay. My name is Ellen Davis, and I'm with O'Connor and Campbell, and I am joined at council table with Dan Campbell of the same firm, and also in the audience is Kirsten Murphy of Hines, Cook & Murphy, who was with us on the brief, and also we have Mr. Tony Cullum of the law offices of Tony Cullum from Flagstaff, and we have 3 members of the SOCA, affectionately we call SOCA, Sedona Oak Creek Airport Authority, because that's too big of something to say, so I'm just going to call it SOCA. So we have 3 members of the board of directors with us today, Mr. Harold Idell, Pam Vizzini, and David Cooper. So if I may pick up from where the court left off in the questioning of Mr. Weech, I too am confused as to what it is that Mr. Weech is asking this court, or even the trial court, to do in this case. He seems to say if he believes that SOCA's RFP process was not exactly what DAKOTA thinks it should be, then SOCA must cancel the RFP and the contract with guidance, which it cannot do, and issue a new RFP and allow DAKOTA to stay on the airport until essentially...
Well, tell me what you think he's misstated. Didn't your RFP say that it would be presented and approved by the Board of Supervisors?
Well, let's back up one step.
Just answer that question.
Sure. it says, the best response, and I'm reading from AB answering brief 3 and on page 2, and it says, the best responsible proponent shall be that proponent which SOCA and Yavapai County may determine in the exercise of their sole, absolute, and complete discretion to be the proponent to lease and operate commercial 135 operations. The word shall defines who shall be the proponent. As to what Yavapai County can or cannot do, the word is may determine in the exercise of their sole and absolute discretion. The words sole and absolute discretion include the right to say no thank you, which is what the county did in this case. It is not disputed as to what happened in the county below. If you look at Dakota's emergency motion, you will see that they agree that what happened is Sedona Airport wrote to the county attorney, and that's IR 65 Exhibit 7 and IR 69 Exhibit 9, 7 and 9. And the county attorney said in 2 letters dated September 7 and September 22nd, it is not our role to participate in the RFP process. And essentially, we're never going to do it. So Dakota has not been harmed by the lack of participation by Yavapai County because they were never promised it. We have assumed that the RFP was part of the settlement agreement, and I would take, even though we didn't appeal, I would take issue with Judge Napper on that point, because the settlement agreement itself.
Well, if I've told him that he should limit it to the stuff that's been appealed, I will say the same thing to you. Focus your arguments on what's actually before us.
Right. Well, the settlement agreement is actually before us, so let's assume, for the purposes of
How is that before us?
the settlement agreement.
I thought this was only about the dissolution of an injunction.
True, Your Honor, it is true on the conditional dissolution of the injunction. The question would be, you know what, you're right, Your Honor, I'm going to take that back. If we're not going to go back and talk about the issuance of the initial injunction, and we're only going to talk about the lifting of the injunction, the interpretation of the settlement agreement is before us only if that it informs our discussion as to what SOCA was to do in getting Yavapai County's approval or opportunity to participate.
Correct me if I'm wrong. The initial injunction said stop and present it to the county.
Right.
Okay. And then you guys sent your emails or letters to the deputy county attorney who said, we're not going to do that. You went back to the court, and the court said, all right, that condition has been met.
I would change that just a little bit. I don't think that SOCA said we're not going to do that. We asked the county to consider.
The deputy county attorney said,
I'm sorry.
We're not going to do that.
Yes, you're right,
Okay.
Your Honor. In that case, I'm wrong.
Back to
You're
the court
right.
and said, we tried.
Right.
Okay.
And we showed them that we had tried, and we did offer them the opportunity to weigh in, and there was testimony that SOCA offered Yavapai County the unredacted proposals as well, so that we did everything we could to perform. And keep in mind that Yavapai County was not a party to the RFP or to the settlement agreement, so we could not gain their participation, which is probably what we could not mandate their participation, which is probably why the RFP says Yavapai County may determine in the exercise of their sole and absolute discretion to be the best proponent. So there is plenty of room for Yavapai County to say no, and that's what happened. So once Yavapai County said no, and also the FAA said no as well. We have emails in the record, that's AB 1 and 2, where the FAA says this is not our job. We do not weigh in on RFPs. And that happened, by the way, before Dakota responded to the RFP in the first place. That happened way back in May. So Dakota knew that before they even submitted their proposal.
Didn't the trial court order below say you could file a motion to lift the injunction once the board, once the county, had the opportunity to review and consider the proposals?
Right.
Did the board have the opportunity to consider the proposals?
Yes, Your Honor, it did.
How?
It said we are not in the business of awarding RFPs.
Yeah, that's what the deputy county attorney or the county attorney said. So
Right.
we're not going to present this to the board.
Right.
So how did the board have the opportunity to consider the proposals if it was stopped by the gatekeeper before it got to the board?
Your Honor, I don't have the exact wording of Judge Napper before me right this second, but I think he said Yavapai County rather than the Yavapai County Board. And if he said the Yavapai County Board instead of Yavapai County,
I
I think
could
that
be
was
wrong
just a
on that, so-
misstatement
okay.
on his point. So the question is, did Yavapai County as an entity consider the proposals in the only way that it could consider the proposals? And the answer is yes. The lease between SOCA and Yavapai County requires Yavapai County to approve the ultimate leases, but not to participate in the selection of the leases. And that's the statutory thing. SOCA is a nonprofit organization created to run the airport, and that creates a level of a buffer zone between the county and the operation. And what the county was saying to us, if you read those letters in the record, is under statute and under lease, this is how these things work. So if, for instance, God forbid you were to remand and say, okay, SOCA, you go back to the county and ask the county board of supervisors to participate in the selection of the RFP proponent, you would get the same result as you have today. So Mr. Weech's idea that if somehow we wrote an impossibility or we wrote an inexact term into the RFP, that means he gets to stay there indefinitely until...
I don't think he said that. What he said was, if you wrote something that's a legal impossibility or factual impossibility in the RFP, the remedy should be to require you to issue an RFP that's not impossible. That doesn't sound like he's asking you to stay there forever.
Your Honor, he would be asking us to rewrite the contract, and I would say he's got the law of impossibility wrong. If you look at AB 39, we've cited those references, and what we say is if the term is impractical or impossible, then the condition is excused, not that you have to rewrite and throw out the contract. I don't know of any case law that says if you have an impossible condition in the contract, you have to throw out the contract. And that wouldn't be consistent with the settlement agreement, which was the agreement that led to the injunction and the lifting of the injunction in the first place. And the settlement agreement says Dakota must vacate no later than 30 days after receipt of notice that an award has been made under an RFP. And that happened. So the question before Judge Napper was, did SOCA perform under the settlement agreement? Judge Napper initially determined, read the RFP into the settlement agreement and said, well, I'm going to read the word award expansively and in Dakota's favor, and I'm going to say you haven't made an award because there hasn't been participation by the county, which is not technically in the settlement agreement. So in our view, Judge Napper was reading the settlement agreement incredibly expansively in Dakota's favor to extend the injunction temporarily in the first place. And so when SOCA performed everything it could possibly perform under the settlement agreement, which was the operative agreement that required Dakota to vacate, then Judge Napper correctly ruled that Dakota was required to vacate. Just, if I may go change the subject for a moment. Your Honor, today is 21 months and 24 days since Dakota and SOCA signed the settlement agreement. Dakota's lease was then going to expire in 3 days. The question before this court is, should you extend this injunction? Dakota has now been on the airport without a lease for almost as long as it would have been had it won the RFP. So we're saying you should lift the injunction because the status quo is that Dakota has no lease. It hasn't had a lease since April 30th of 2017. SOCA is a landlord with property rights that are being trampled.
Has it been receiving rent from Dakota?
Yes, Your Honor, it has, but it also has been sued by Guidance. And Guidance filed a notice of claim, which is, I think it's AB 8 or 9, and asked for...
So there's a dispute, as one might expect. That's why we have the injunction in place. There's a dispute over who should be there. But it's not as though Dakota is just robbing SOCA blind by squatting on its land, right?
Well,
it contends it has a right to be there. It's paying for that right. The payments are probably being accepted under protest, but It may not be quite as dire as you're suggesting.
Well, Your Honor, there's a lot of facts that are pending in the trial court that that are before me, that I know of, that I can't introduce into this record. So I would disagree with your characterization, but in order to explain to you why I disagree, I would have to go outside the record.
Fair enough.
Okay. And one more thing. Let's talk about catastrophic loss. Catastrophic loss is not the issue. The issue is it irreparable loss? And it's not. Dakota tells you they've been at the airport for 25 years. At this point, they should know what their profits and losses are. If they don't, get a new bookkeeper. That's not on SOCA. This is a classic damages case if there were damages, particularly now. We are 21 months and 24 days into a 24-month RFP. If Dakota has suffered any damage, has been damaged at all or would be damaged by leaving, then they can calculate it. They can recover that in damages. What Dakota is essentially arguing, and I'm not sure how they get there, is that their harm comes from ever having to leave the airport, period, because their business would shut down. And the only fact that Dakota gave Judge Napper as to why their business would have to shut down if it weren't operating at Sedona Airport as opposed to somewhere else, and these are helicopters and not fixed wings, is that our Part 135 certificate requires us to keep a fixed base of operations at Sedona Airport. Well, there was evidence before.
Isn't this really gets afield of the whether or not they met the condition?
It is true, Your Honor. It goes to whether or not there's any sort of catastrophic irreparable harm. There's not. Dakota doesn't have a Part 135. There's no FAA regulation that requires Dakota to stay at the Sedona Airport. You
guys appeal the initial grant of the order to stay. I'm sorry, it's not stay. I'm drawing up
the injunction.
The injunction. Thank you.
No, Your Honor, we didn't,
Okay,
because
then those issues are resolved. And again, we are here on the notice of appeal from whether or not the stay would be lifted.
I mean, I think we're acting on statements from a couple of cases that just say that when there's an application to dissolve an injunction, the court doesn't re-examine the basis for the initial issuance of the injunction.
Okay.
There's a clear condition.
Your Honor,
that seems to be the issue.
I will stop talking about the balance of harms and catastrophic harms at this point in irreparable
As
injury.
Sean indicated, we tend to resist micromanaging superior courts and generally wait till the end to resolve final judgments.
The facts you have before you on whether or not the condition of the initial injunction were met is that Yavapai County, through the county attorney, was given the opportunity to participate, and it declined to participate, and those facts aren't disputed. If you remanded, you'd end up in the very same place. The question as to whether or not the county violated the open meeting law, I think is not before you because it wasn't a condition of the lifting of the injunction. And it's also not before you because I think Mr. Weech is just wrong on the law. The county attorney can decide what goes on the county's agenda, and if it doesn't go on the agenda, that's not a violation of the open meeting law. I would point you to the Fisher versus Maricopa County Stadium case, Arizona 185, Arizona 116, that essentially says a public body can take advice of counsel and decide to act or not act in private. It doesn't have to do that in public. So there was no violation of the open meeting law, and there was certainly no violation of Judge Napper's orders in lifting the injunction. I was going to go to the issue of whether or not Judge Napper was required to hold a second evidentiary hearing, but because...
I think that's relevant.
Okay. All right. Dakota had 3 full days of evidentiary hearing, after which Judge Napper issued a conditional injunction. That condition of the injunction was not appealed, so I think that's not before you today. The question is whether or not Dakota would have been entitled to yet another evidentiary hearing after SOCA made the motion to lift the injunction, DAKOTA had 3 chances to ask Judge Napper for an additional evidentiary hearing or to delay hearing that until SOCA answered. SOCA's answer wasn't due at that point. One when it responded to the motion to lift, one when it asked for oral argument, and one in the oral argument itself. It didn't. That issue was not brought before Judge Napper, and it was not preserved. Had it been preserved, the reason for that rule is so that Judge Napper could fix it if fixing needed being done. But, Your Honor,
Were there any disputed facts
No.
relevant to the issue of dissolution, whether condition had been met?
in Judge Napper's mind, no. And I think he was correct in that ruling, because there was the RFP says Yavapai County may determine in the exercise of their sole and absolute discretion, and I think there's no dispute that that happened. Yavapai County exercised their sole and absolute discretion. And after that happened, it was proper to lift the injunction, and as Judge Napper found, there was then no reason for DAKOTA to stay on the airport. And there's no reason for DAKOTA to stay on the airport today. Were there any other issues that we haven't addressed?
No, thank you very much.
Thank you.
The wonders of technology allow me to read you the order, but the wonders of technology also allowed for it to go off 3 times while I was waiting to get back up here. The court asked, and here's what Judge Napper ordered. It is ordered SOCA will be allowed to file a motion to lift the injunction once Yavapai County Board of Supervisors has had the opportunity to review and consider the proposals submitted by both parties and determine who to be the best proponent. That's the language from Judge Napper in dissolving the injunction. As to, and I'm going to shift to the evidentiary hearing. We've briefed before you the rule as to evidentiary hearings. It doesn't say that a party has to request an evidentiary hearing or they've waived it. The rule says the trial court must hold an evidentiary hearing. Had the trial to do what?
Presumably to hear evidence, right?
Presumably to hear the evidence that was referred to by Ms. Davis just now, that was only included in their brief and which was totally inadmissible hearsay, and that those sort of rules and those sort of things would have come up for a challenge in an evidentiary hearing to what that hearsay was, to the fact that it was not a ruling from it was not a decision by the Board of Supervisors, but rather the gatekeeper who wrote and said, we don't do that. And yet the order says the Board of Supervisors has to have this opportunity. If the gatekeeper kept the Board of Supervisors from doing that, and they did, then because the Board of Supervisors can only decide and consider things
Gatekeeper
in open court. I'm not sorry, in
Gatekeeper
open
isn't
meeting.
just a fictional character operating independently. The county attorney is the county's agent. They hire the county attorney to perform that role.
This order says the Board of Supervisors has to be given these opportunities, and there's nothing there that says, no evidence at all, not in an evidentiary hearing, not even in their briefing, that this was complied with.
But you had a chance to respond to their request to lift the stay.
Pardon?
You had a chance to respond, and you didn't contest the fact that they had sent this. So I'm trying to figure out what was the contested issue of fact. You've raised some legal issues as whether what they did is sufficient to trigger the county's obligations or meet those requirements, but it doesn't seem like the underlying facts were in dispute.
No, we did contest it. We contested it hotly that they were using inadmissible evidence to show compliance with this condition. We did it not only in our response, but at the oral argument on their motion on the 28th of November of 2017.
You contest the underlying fact that they presented it to the county attorney, and the county attorney said, thanks, but no thanks.
To the county attorney, the answer to that, we do not contest. Well, Your Honor, we don't know. We have letters that we didn't have any discovery or any disclosure on. We didn't have the opportunity to bring that person in on a subpoena to testify at a hearing. Did you actually write this letter? So yes, we do contest it. We may well have lost that, but we did not have the opportunity to contest it because it was
Could you have
simply.
done so in good faith? Do you have any reason, as you stand here now, to assert that you believe that those letters were somehow forged?
We do not have any evidence at all because we did not have any disclosure, any discovery, or a chance to examine that person and ask him those
Did you
questions.
at any point ever tell the court, these are issues we need to resolve, we'd like a evidentiary hearing on this?
In our response, we noted the fact.
You be careful to answer the question I asked. Did you say we need an evidentiary hearing?
I don't think so.
An evidentiary hearing?
I don't think so, but the statute requires it. It doesn't require us to request it, and we didn't openly waive it, nor could it be waived. The statute says that the court must have one, and it also says that it cannot be considered until after an answer is filed, and SOCA had not filed an answer. They could have, but they didn't, even though they'd filed a motion to dismiss. That did not prevent them from filing an answer as well and complying with that so that could go forward. We've briefed this in our briefing, but I want to come back to the fact that
let me be real clear right now, because even if there is
my
an
time
argument,
is stopped on here.
I'm aware of that. Let me finish my question. Even if there is an argument that there was an error, you still have to demonstrate prejudice. So tell us right now what you would have shown at that evidentiary hearing.
We would have shown at that evidentiary hearing that the county attorney, and only the county attorney at best, made a decision, and that SOCA did nothing past that to comply with his court's order on this condition that it put on there.
But SOCA didn't claim that they did anything beyond just sending the correspondence to the county attorney.
That's correct, and we would have argued that.
That's why I'm really struggling on what the contested fact is. I don't see that there's any argument there. I mean, you don't seem to really be accusing them of making up the fact that they sent the correspondence to the county attorney. So your argument is a legal one to the court below, which is this either wasn't sufficient under the order granting the injunction, or legally was insufficient because it didn't meet the requirements of open meeting laws, things like that. Am I missing something?
Not on those issues, Your Honor. You're dead on. But the point is that there was not an evidentiary hearing, and at that point in time, disclosure was not provided, and discovery was not allowed, was not taken. It just wasn't done, and the evidence.
Actually, the rule actually doesn't allow you discovery before the hearing.
Correct.
So
But
where's the prejudice from not having the hearing? I'm really struggling to find that.
all right.
You've told us that you see a distinction between the county attorney and the county. That's a legal question. We can evaluate that.
Understood.
So what other evidence did you need to present? What proffer did you make?
You're absolutely correct that we did not have the opportunity to do discovery, so we would have subpoenaed the authors of these documents and had the opportunity, as due process allows, to question them on the stand. What their answers would be, we don't know because we weren't given that opportunity.
So the rule doesn't say that you have the right to subpoena to do discovery before the evidentiary hearing, and discovery is not a matter of due process.
I'm not disagreeing with you on that. I was talking about subpoenaing them to the evidentiary hearing in order to be able to question them there, just as we had the opportunity and did subpoena people to the 3 days of hearing on getting the injunction.
And you've had the opportunity to litigate this case and wanted to tell us all about the many things that have been going on in the time since this case was this appeal was commenced. Have you asked anybody, are these letters forged?
No, sir, we've not.
Okay, thank you.
Since we interrupted you, if you have a sentence you want to finish, a thought or something like that.
No, other than to reiterate that the court's, I'll just conclude with this conclusion. And these are issues of law. The trial court rewrote, whatever you want to call it, something different than what was in the RFP. Point number one. 2, the county cannot act unless, and the order that he issued, number 2, is that the county board of supervisors, not a county attorney, not an agent of the county, but the board of supervisors be allowed to review the proposals and to determine a winner. 3, the evidence that was presented to show compliance was not in an evidentiary hearing and was totally inadmissible hearsay and conclusions of counsel. Thank you very much.
Thank you. Thank you all for your briefs and presentations here today. We will take this matter under advisement and issue a written decision in due course. We are now at recess.